I'm manufacturing a product to be sold in the US and like to duplicate the packaging box from another brand. The brand in question has patents on various other far more complex type of packaging, but I haven't been able to locate any for this style of box. It's basically just a chipboard box, but the style, shape, and how it's glued together is semi-unique. We duplicated the packaging by reverse engineering and unfolding the box and recreating the die cuts. So it's exactly the same. I click to run it by my attorney, and he doesn't think it's something they could even get a patent on, since it's such a basic design. But I'd like to do more in-depth search to confirm before we go into production. Where would I even start searching? This company that has thousands of patents for various types of products. And like I said, this is my mind goes to like this.
This is definitely like an Apple product.
Yeah, like okay, Anyway, so okay.
And yeah, this is obviously a design patent question, and I can even jump in on the trade dress side because this is a trade dress issue too.
I will say the bulletproof answer is going to be to hire a patent attorney and get a determination on freedom to operate. That is what FTO stands for. If I can stretch, there it is. Have you looked at the patents that are issued and even those that may be pending to see whether you're going to be stepping on the toes of current rights holders or future rights holders? So having that search, looking at specifically, if you know who this product maker, you can do a query, look for specific words. If it's a utility patent, but likely it's a design, so you'll be looking at design elements and shapes. So having a thorough search done is important. And if you're aware of any patents specifically, you can look element by element and get a claim chart built out. That takes money and time, right? So if you don't have any money and time, go get some more money. And you're going to be serious, because if you go out and start making the identical or very similar box as someone else, and they've got the funds to go enforce their rights, you're going to be hit with a cease and desist and be liable for damages. So don't do it if there's likelihood of infringement.
Yeah, change your box a little bit.
Yeah.
So I've been through this whole box manufacturing process, custom box designs, die cutting, creating a custom die basically to stamp the boxes for the folds and all that kind of thing, and cut out the paper from the large sheets. Just edit it a little bit, make it a little bit different, make it different enough. I mean, sometimes people ask me like, oh, does it have to be like 25% different, 50% different? There's no answer to that, but I think as long as you can say that you're not directly copying the box, you have a better argument if this company did come after you.
Yes.
But I think, your answer is great, JD. I think it depends, right? It depends on whether or not they have a design patent on the box.
Yes.
Depends if they have trade dress registration on the box.
Yep.
Trade dress protects the look and the feel of something without any utility, kind of similar to design patents. But, Apple does love to large companies love to file design patents or design trademarks for trade dress.
I think they can do more with it. That's sort of the unfolded form, right? Or I think they can do more with trade dress. With a design patent, you're limited to a final fixed form.
Got it.
So, in terms of, it does in general cover scaling up, scaling down. So we just made it larger. You're still infringing in terms of the overall dimensions, the shape, the appearance. It looks the same. It's just on a larger scale. So you have to change, some of those sub dimensions. So the overall end product looks different. And the actual answer is an ordinary observer test. Is would an ordinary observer or a customer think one is the same as the other, right? Would they be able to equate? And it's a confusion kind of standard almost, like similar.
Yeah, I mean, and then the flip side, the opposite side of the coin for this, for the trademark, is that if a viewer saw this individual's box, would they think it came from Apple or whoever the other company X is, right?
Yeah.
If that's the case, then there's a likelihood of confusion between the two, and that's a problem.